Okay, Shannon, you can put us on the record.
Go ahead.
Okay, let me find the file. Okay, this is a matter of Berg versus Berg. Mr. Phillips for the plaintiff, Ms. Pearson for the defendant. And let's see. So I see hearing briefs, but I can't see what the hearing is on. What's the title? It says miscellaneous hearing. Okay. Is this a hearing that I scheduled?
Well, Your Honor, we were in front of you on the 19th, and according to your ruling, I was to provide a detailed accounting of our foreclosure balance, and I was to adjourn the foreclosure on a weekly basis. And pursuant to your order, which I believe it's dated May 5th, if the plaintiff was unduly delaying responding to the foreclosure, I could call your office and bring this matter back up to you for further hearing. And that's why we're here, because they are doing nothing and I need to get this thing moved along. We were, like I said, we were before you on the 19th. I gave him a very detailed accounting of what the foreclosure balance was, eliminating something that you had struck, and that's my Exhibit A to the hearing brief. They responded to my claims and made some counterclaims, but since that time have done nothing to actually calculate what they believe the balance is. And they made frivolous claims, which is causing undue delay. And that was Exhibit B to my brief. Exhibit C to my brief are the affidavits that I provided to them.
Let's talk about Exhibit B.
Sure.
It clearly is identified as a settlement offer. What in the world are you doing submitting that to the court? You know that settlement discussions are inadmissible. Why in the world would you attach that as an exhibit?
Your Honor, I know it says settlement offer, but there really is no offer in there. If you review it, they're responding to the claims that I made in my foreclosure calculation, and they're making some counterclaims. Nowhere in there is there actually a number as to what a settlement would be. And under MRE 408, the offer of compromise subject to that court rule requires a promise to accept valuable consideration. There's nothing in there. And that's exactly what I told Mr. Phillips. When I received that, I responded to him the exact same day. And I said, this is not an offer. There's not even a number in here. And since that time, Your Honor, since we've been before you on the 19th, almost 6 weeks ago, they have not once come back and said, this is what we think the number is. So no, I don't consider that it says settlement offer at the top. I mean, that's what he titled it. But if you read it, there's nothing in there no promise of valuable consideration. There's a response to claims and counterclaims. And another reason that I've offered it to you is because it can be offered for another purpose. And that is because he's submitting these frivolous claims to cause delay in the foreclosure.
What relief are you seeking today?
Your Honor, I'd like to be able to proceed with the foreclosure. They have not given me a counter number as of yet. And in my brief, I've attached Exhibit E, which includes items that make up the balance that we and that they have not even submitted anything to refute. So I'm asking that the foreclosure be allowed to proceed with a value of 146,747.53.
I did note when I read Mr. Phillips' response that a settlement offer was extended to you, but you got no response.
No, Your Honor, that's not true. What he's referring to is that letter. And the letter that actually has no offer in it. And I responded to him the exact same day, April 27th. And I said, this is not an offer. There's not even a number here.
All right,
So,
I hear you. I was under the impression that there was a subsequent offer. Let me hear from Mr. Phillips then.
Thank you, Judge. First, would you be willing to let me know if you have a copy of my objection to Ms. Pearson?
That's what I was referring to. Your objection says, before filing the objection, undersigned counsel offered to settle. That's what I was asking her about.
Well, to be clear, I was asking to settle the issue of her filing my settlement offer with the court. I wanted her to agree to withdraw it to save me the time of having to file an objection. Offer, I am confident that that's a settlement offer. Although it doesn't indicate an actual number, it does agree to the methodology by which we could calculate what is due on the mortgage. My client is ready to list the property. We have a realtor. We'd love to get it on the market. The problem is I can't list it until I know what the mortgage payoff is, because I can't close without paying off the mortgage. Nobody's going to be willing to part with more than $100,000 to buy this lot, not knowing if an underlying lien would be satisfied.
Well, it sounds like Ms. Pearson is indicating that the mortgage payoff would be $146,747.53. Is that correct, Ms. Pearson?
that is what I am claiming. Yes, Your Honor. And they've never given me an opposing number of what they believe the number is. That's the problem. We're in limbo here.
Gotcha.
May I be heard?
That's why I'm here.
Excellent. Thank you, Judge. So the number for the attorney fees claimed by opposing counsel is one that can be easily determined by reference to the mortgage. The mortgage states that the statutory fee is the one that's allowable, and the statutory fee, I've cited the statute in my motion for partial summary disposition, is MCL 600.2431 sub 2. It provides that when there's a mortgage of more than $5,000, the attorney fee is $75. That's directly from the mortgage. It's in the four corners of the document, and that's the fee to which the parties agree would be entitled upon foreclosure. Ms. Pearson is seeking something near $100. Even if the court were to find that attorney fees greater than the statutory fee were allowable, not all of those fees are even for the foreclosure of the mortgage. So I think you can determine as a matter of law, based upon the statute and the mortgage itself, what the statutory fee is. I think it's $75, and I've specified. The other issue is the maintenance that was performed by the defendants on the property. There's nothing in the mortgage that allows them to maintain the property. I think the affidavits submitted by Ms. Pearson are most telling on the subject. The parties, the defendants sided the house. They installed a concrete driveway. They installed a deck, a porch, doors, steps, none of which is allowable under the mortgage. The mortgage states that the defendants can foreclose upon the mortgage. They chose not to do that. They instead chose to put a bunch of money into the house and then are seeking to collect 10% interest on that. And so those are at least there are other issues, but determining those issues would help us derive the number that is owed on the mortgage and get this property on the schedule at the auction, and also allow us to list the property for sale on the market. As to, sorry, I lost my train of thought. As to the settlement offer, Ms. Pearson is correct. I sent a settlement offer late in the evening one night. It's the settlement offer that's attached to her hearing brief. It's the one to which I object. And I received a response about an hour later. And and Ms. Pearson's statements here are clear. She rejected the settlement offer. But my position has been, I need her clients to reject the settlement offer. I believe that Ms. Pearson has an obligation under the rules of professional conduct to bring settlement offers to her clients' attention, and she has been unwilling to do that. If I can get any indication that her clients are rejecting that offer instead of her, which is what she has actually stated, I'd be happy with that. And I need something in return. I need to know why they think that the mortgage says that they can get attorney fees, actual attorney fees, rather than statutory attorney fees. I need to know why they think that they're able to install driveways and patios and use the property when the mortgage doesn't say they can. It simply says they can foreclose. They could have foreclosed 10 years ago. They chose not to. And I need to know why they expect those costs when nothing in the mortgage addresses it. I can't negotiate by myself, so I at least need a counteroffer. I have not done any, I have not, at least in 408, an existence of a settlement offer can be used as evidence to negate an allegation of undue delay. I don't think I am unduly delaying. I have sought information from Ms. Pearson. I haven't gotten it. I have given settlement offers to Ms. Pearson. I haven't gotten responses. I have prepared and filed a motion for partial summary disposition to bring the outstanding issues to your attention. I have not yet noticed it because this hearing was noticed prior to my noticing my motion for summary disposition. And so I wanted to see what would happen today before I proceeded any further. The issues that I'm asking the court to address are issues of law. You can easily rule on them. It would resolve at least what's due on the mortgage and would allow us to proceed.
So I see the pictures that were attached to the affidavit that was Exhibit D, Ms. Pearson.
Yes.
Do those disclose the current state of the interior of this home?
Yes, Your Honor. And that is the condition of the interior since the date of death. I mean, some things have been removed, but this junk is there. One of their claims is that my client has been using this for their personal storage. This stuff has all been there. None of this is my client's. This is the way it looks today.
So clearly somebody gutted this building and was in the process of reconstructing the interior. And I saw that there was also some exterior work that was being done. So the deceased is the one who was in the process of renovating.
What the decedent did, Your Honor, was there was a small, I guess, cottage there. He took that down to build a nicer, bigger home. So the decedent actually did this.
You.
Yes.
So this isn't a rebuild. This is a new structure.
Yes, this was a new construction. Yes. And so, yes, this was all of the decedents. This was the condition it was in because he was doing the work himself. It was going slowly. He was having money problems. Right.
So, and this is essentially the condition it's in today.
That is correct, Your Honor.
So all of the maintenance expenses that are being sought in your looks like Exhibit E. What do those consist of?
Okay, so that's another issue. If you'll recall, Your Honor, my clients under the mortgage are allowed to take steps necessary to procure insurance and prevent waste. When the decedent, when Mr. Berg passed away, my clients discovered that the taxes had not been paid, the property had not been insured, and there was township issues with permits and the property not being completed. The state of this property, Your Honor, what happened is the day after decedent passed away, his family was getting calls that people were coming in and out of the house and taking things because the house had no doors, no windows, no roof, like literally no doors, garage door, front door, everything. So and it had tieback on it because he hadn't completed the siding. So what my clients did, Your Honor, was they put in the garage door, they put in a front door, back door, they put the roofing on, they put the siding on. They were required to put, because there was a 6-foot drop outside the door wall, they were required to put a deck and a porch on, and that's all they did. They finished the exterior. They were able to get insurance, and since that time, it's been insured. So this was done to prevent waste because, again, there was no roof. It was raining inside the home. There was flooding inside the home because there was no windows on the crawl space, and because there was no concrete there, so the water was rolling back into the crawl space. So, and when they talk about putting in a concrete pad, that's not entirely accurate. This is a shared driveway, and the water was running into the homes, and so jointly, they jointly agreed to put in the cement because it directly prevented the water from going into the crawl spaces, but then rather pushed it out to the road and down the hill into the lake. And that's all they did. They got the home put together so the township wouldn't condemn it, so they could get insurance. So it's not what they're making it sound like. But I have a couple other comments. I am extremely offended about Mr. Phillips making allegations of professional misconduct, and that I have an obligation to disclose my conversations with my clients and get something signed by my clients and give it to him. That's not what my duties are under professional rules. I represent my clients. I provide responses on behalf of my clients. And my clients did authorize everything I've done in this case. With regard to the attorney fee issue, Your Honor, if you look at my Exhibit E, you'll see that I have not even included attorney fees. So that's a non-issue.
Exhibit E shows attorney fees of $3,850.
Yeah, but if you look right above that, that's not included in the number I gave you, 146,747.53.
Oh, I got you. That's with the attorney fees subtracted.
Exactly. So that's a non-issue.
Gotcha.
I haven't even included that. And when it comes to these maintenance expenses, if you look at the breakdown, there's the base and the interest. He's complaining about the interest. He could easily take a calculator and say, okay, this is the amount we agree on. Take the interest out. This is the problem, Your Honor. I have never been given a counter number by them that we can agree on and get this thing moving. And instead, I'm having to deal with frivolous claims. And if you look at when he says that I did not respond to this letter of his on April 27th, that's entirely false. That's exactly what I did with my affidavits and pictures. I responded to their claims that my clients were using and maintaining the property, which was false. I responded to the claims that my clients were building and using a dock and had to pay dock slip fees, which were false. I responded to the claim that my clients were using this building for personal storage, because that's false. So I did absolutely.
All right. So let me. It's clear to me that there are at least some issues in dispute here, or potentially. I've got a motion for partial summary disposition that I think I'm going to need to rule on before I'm in a position to say you can go ahead with your foreclosure sale. Mr. Phillips, You filed your motion. When was it filed?
It was filed last week, Judge, but it needs to be.
Say it again.
I believe I
Say
sent.
it again. You
it
broke
was
up.
filed last- I believe I sent a copy to Ms. Pearson by email.
You broke up again. You broke up again. Try again.
I apologize. Am I being heard at present?
I can, but each time you speak, you break up, and I miss part of the sentence.
All right. If I can't be heard, I'll simply call in on a landline. Is that acceptable?
Just try one more time to tell me what you were trying to tell me about when your motion was filed.
It was filed last week.
Oh, okay. So there's time for Ms. Pearson yet to respond to it. I think it needs to be noticed for hearing. I'm going to continue to adjourn the sale until I can see her response to that. I want there to be some communication between now and whatever that hearing date is. I'm going to expect your clients to be present for that hearing date, and I may very well conduct some kind of a settlement conference on that date.
Yes,
when-
Your Honor, can I ask that the plaintiff be required to give me some number? I mean, I have given them a number. They have never come back and said, this is what we think the number is. That's really the problem here.
It's not going to settle without a number. I can't compel them to make a number, but I can tell you, Mr. Phillips, if your client has any interest in resolving it, you should communicate a number. That just makes sense. Not a formula, a number. So let's try that. Let's get that conversation going. Whether it's going and whether a number is communicated or not, before then, there will be some communication when I conduct a settlement conference.
Yes.
When will you be noticing your motion for hearing? I hear them on Mondays or Wednesdays at 3.
How much time does, I normally give 21 days under the court rules. If Ms. Pearson would like it earlier, you can order that it be done earlier.
Would you need to, you filed a hearing brief, ma'am, that sets forth your position. I'm assuming a response to the motion is probably not going to take you a whole lot longer to prepare.
No, Your Honor, my position has been presented to you in my brief and to Mr. Phillips in my affidavits. So I don't think there's really much more I can add to a response to summary judgment. As I indicated, he's raising this issue on attorney fees, and that was not even included in the brief I gave you today.
We'll treat your hearing brief for today as your response to his motion then?
That would be fine with me.
Could we hear this? Let me see. Let me see how my schedule next Wednesday looks. I have one motion scheduled for three. Why don't we set it for 3:30 next Wednesday, June 2nd.
3:30.
That works for me.
Make sure your clients are available. If there hasn't been any significant movement in settlement, I'll at least want to know the party's position next Wednesday.
Thank you, Judge.
Thank you, Your Honor.
Would you please, Shannon?
Yep. Just a miscellaneous, or how do you want?
Hearing on motions for partial summary disposition.
Gotcha.
Thank you. We'll see you next week.
Thank you, Judge.
Thank you, counsel.
June 2nd at 3:30, Your Honor.
Yes. Oops, and I accidentally clicked you out. Sorry, Shannon, can you re-sign?
Oh, yeah.
Sorry about that. So let's see. Hilltop? Is everyone here on Hilltop?
Yeah.
Okay, I got Mr. Bonham in the waiting room.
morning.
Good morning. Let me adjust my camera just a little bit. All right, looks like we can see everyone that's here now. So this is a matter of Hilltop Manor versus auto owners. Counsel, could you each state your appearances, please?
Attorney Zach Bonham for the plaintiff.
Rick Girodad on behalf of Defendant Warner Adjustment Company.
Christine Horn on behalf of Defendant Auto Owners Insurance Company.
I'm sorry, maybe.
Christine Horn on behalf of Defendant Auto Owners.
All right, there are a number of motions up today. I don't have a preference as to what goes first. I guess I could hear this motion to quash subpoena first. Does that make sense?
If you'd like, Your Honor, auto owners did file first, so I'm fine with them going first if they'd like to.
Okay.
All right, fair enough.
So your our first one up today is Auto Owners' motion to compel more specific answers to our first request for interrogatories and production of documents. Just a brief procedural breakdown. We submitted these on February 3rd. Plaintiff filed a motion for protective order on the 5th. That was granted. However, there are some disputes over the language of the order, which we returned on April 16th and resolved. At that time, the court also heard our motion to compel discovery responses, ordering plaintiff to produce responses on or before May 14th. We did receive responses on May 5th, but upon review, it became clear that meaningful responses were not provided to questions 2, 5, 7, and 9. I can go through each of those questions and our issues with same. Regarding interrogatory request to produce number 2, it was aimed at obtaining information regarding what repairs, if any, were done to the insured location. In response, plaintiff directed us to Mr. Kowaleski's deposition transcript, some invoices from the mitigation company, photographs, a sworn statement, and proof of loss, and invoices. The issue with that is none of the documents are responsive to the interrogatory. The photographs concern capture the insured premises at the time of loss or during mitigation. They don't show any repairs. Same thing with exact recon. It's a mitigation water remediation estimate. Does not address repairs. The sworn statement and proof of loss only documents the damages being claimed. And finally, the invoices and receipts fail to demonstrate what repairs were completed, when, how payment was made, various things to capture what we requested. So we're asking that that be supplemented, specifically outlining what repairs were completed and documentation that supports that. In response to, our next one is interrogatory request to produce number 5. That one concerned or requested documents for inspections of the guest house and barn, as well as repairs. Mr. Kowaleski testified at the time of the loss, he was substantially renovating both the guest house and the barn. His tax records further show that over $100,000 was spent in improvements in 2018, the year prior to the loss. So we requested, issue this interrogatory request to produce as it concerns plaintiff's financial condition. We pled a affirmative defense of intentional acts, which allows us to submit evidence of a financial motive, maybe for causing the loss or an attempt to defraud auto owners. So evidence of their financial condition leading up to at the time of the loss is very relevant, which is why we submitted that. In regards to request to produce number 7, we requested copies of any and all notes taken by Mr. Kowaleski. Again, during his EUO, he testified that he took detailed notes for maybe a 12-minute period. Auto owners was obviously not present at the time of the loss and did not have an opportunity to inspect until mitigation work had already been completed. So what Mr. Kowaleski observed at the time the loss was occurring is very relevant. I believe in response to that, plaintiff objected, saying work product privilege and attorney-client privilege I dispute whether either of those privileges apply. And our last issue is with number 9, which again requested business records from 7 to 8 sources. Again, the business records are requested to see and ascertain plaintiff's financial condition leading up to the loss and at the time of the loss. In response, plaintiff either states that they were previously produced or instructs auto owners to contact plaintiff's CPA, banks, and other keeper of records. In regards to the response that they were previously produced, that's just false. We have been requesting these since the EUO process. Then we did not receive them, which is why we now seek them in form of a written discovery request. As for plaintiff's instructions to contact CPA, banks, keeper of records by way of subpoena, it's just burden shifting. Simply because plaintiff does not have these in their physical possession does not mean they don't have to take steps to seek them out and produce them. Plaintiff has previously produced some CPA records, not the amount we requested. So they have access to them. And now they're basically saying, we don't have access anymore. You can get them by subpoena. I don't believe that's proper. They can reach out to their banks, CPA, obtain copies and produce them. So those are the ones we take issue with. We are just asking that they supplement them, respond accordingly, and produce the records. I believe we asked for it in 7 days.
Response?
Thank you, Your Honor. I know that Ms. Horn wasn't at the last hearing that we were at, but I think it's worth recapping. On March 5th, my client filed for divorce from his wife. They had been together for several years. They had a tumultuous relationship. They actually both ended up filing for divorce against each other in separate counties. And as this is going on, 20 days later, his stepson dies in a head-on car accident in Hillsdale County. That's what was going on around the time of the last hearing that we had. And I brought this up to the court and I said, there are personal circumstances going on with Mr. Kowaleski that's making it difficult for me to get documents from him. The emotional toll, the psychological toll being on him is something more than any of us would want to bear. And not only are you going through a divorce, your stepson that you helped raise as a child dies. So that's the background here. And that the court told defense counsel that if I needed an extension of discovery, it would be granted. And I ended up needing an extension. I wanted to make sure there wasn't anything additional that I could turn over to auto owners. And I asked Ms. Griffin for a 2-week adjournment. That's it. Or extension, I should say. She told me no. I have that in my response. She told me no, absolutely not. So I got together what I could that same day and I turned over everything that I have. There isn't one document in my possession that auto owners doesn't already have that isn't protected by any kind of privilege. There is no benefit to my life to not turn things over. Okay, that's really where we are. And since that time, auto owners has brought another motion to compel against us, even though we've turned everything over. For the documents I don't have in my possession, custody or control, or my client, I told them who has the keeper of the records and who will have those documents. And what did auto owners do? They sent the subpoenas off. The records were going to be due on May 21st. So a week ago today, they would have the records. There's no point for today's hearing. I had a hell of a time of trying to get Ms. Griffin to agree to a telephone call with me so I could try to work this out prior to today's hearing. And when I told her she has all the records that I have, and I told her exactly who to go to, because they don't trust my client, they think he's hiding something. Well, who better than the keeper of the records to give it to them? Exactly what they want. I'm not objecting to any of those things. But she said, tough, we're going to do the motion anyhow. That's where I am. And on top of that, what do? They sent a subpoena out to my client's wife while her son died, going through a divorce. And now this case is going on. They are doing nothing but harassing my client and his family. She was an employee. She worked there a few times a year, as an event coordinator. She wasn't there on the day of the loss. But I told them in my first response, hey, don't subpoena her. There's spousal privilege. They did it anyhow. Then they sent a subpoena to Don Kowaleski for properties, one that he doesn't own, and that's verified through public records. They could have found that out themselves. He doesn't own these properties. And then on top of that,
wait, let me ask you about that. Does he own the entity that owns the properties?
There's one property that he has Hilltop Investments, but the other properties that were sold, don't ask me the exact date that they were sold, but they were sold sometime in the last 6 months to 2 years. I don't remember exactly when. We don't have those. But then there's payment histories for no set time period. So that's where we are with that. As far as sending out the subpoenas, I don't know what else I can give to them. The subpoenas are the best source for their records. They have them. That's appropriate. The court rules say that we're supposed to turn over documents that I have in my possession, custody, or control, and we did that. I don't have anything additional to turn over to them. And I told Shelley that on the phone. I wish she was here today so she could verify that statement, but I don't have anything else to turn over to her.
But don't, I mean, your client's CPA is still your client's CPA?
Ask that question again. I couldn't hear you.
The CPA for the time period in question is still your client's CPA today?
Correct.
Well, I mean, although they have the ability to subpoena directly from a CPA, and probably should if they don't trust your client to turn everything over, your client does have an obligation to, when something in the possession of a CPA is something of his in the possession of a CPA, has an obligation to gather that from the CPA, doesn't he?
I would say it's not in his custody, possession, or control. I'm trying to get it from the CPA.
I think that's in his control. All he's got to do is pick up the phone and say to his CPA, hey, I need those tax returns from 2019 or whatever it is. I think that is an obligation of a party to a lawsuit, to gather things from their attorneys and agents.
Well,
it may be moot at this point if there's an outstanding subpoena.
It would have been helpful if I got the extension. I could have done that. Shelley sent out the subpoena 2 days after I sent in my responses. I could have done that, but I didn't get an extension.
Judge, if I may, although I'm not directly involved in this particular motion, I would, had auto owners not requested, I would have requested the same records. And I'm fairly certain, I don't have the policy here, I'm fairly certain that in order to bring any claim of this nature, the policy requires the policy holder, and I don't care if it's Mr. Kowaleski or his accountant or somebody, to provide certain documents. I would assume these documents are included. So they have an obligation under the policy to actually obtain these documents in order to submit a claim. Because what happens, Judge, is auto owners brings a motion saying, hey, you didn't get the documents, so you're not entitled to bring your claim. And what do? Well, they say, okay, well, give us time to go get the documents. Well, I think that's what they're trying to do here, and shortcut that process.
All right, but in any event, I'm not here today to enforce the policy. I'm here today to enforce the discovery rules.
They have the documents.
Okay.
Don't have anything additional.
So I don't have a problem giving you some additional time to respond, but I want to hear about the ones that you have objections to.
Sure. Well, as far as objections, that really puts us at, I believe it's just the note from Mr. Kowaleski as far as objections. I mean, well, I guess I'll touch on the idea of the any documents as far as the guest house and the barn. I asked Shelley in the record, well, in my response and on the phone, what specifically are you looking for? I'm now told something about renovations for the guest house. I'll look and see what we have for those, but I'm not aware of what renovation documents we have for it. A lot of the time my client does the work himself because he owns a contracting company as well. So I'll see what exists. I have no problem turning those things over. They only benefit me to show that, you know, he did the work, that he wasn't short of money. He didn't destroy his own house. I'm happy to turn those things over. I haven't found those records. If I find them, which I'm going to look for, I'll turn them over. But I can only turn over what I have.
So how come you're the one looking for documents instead of your client?
Well, we do it together, Your Honor. I have him, you're not going to believe, he has these massive files, these bins.
I got you.
And we go through them together and we're trying to look and find out what we have. So he's old school. That's how we do it. As far as
I got to assume that if he's making improvements to income producing properties, that he's maintained some record of those improvements. Otherwise, he won't be able to either capitalize them or, to the extent they can be written off,
and that's
offset taxes with them.
And that's part of the things, Your Honor, that I would hope that the tax accountant would have, the CPA would have turned over, because if it reflects in his tax returns that he had $100,000 in renovations, I assume there's some kind of supporting documents for that the CPA would turn over to auto owners. That's part of my thought when I was talking to Shelley, is that if you want these records and you don't trust my client, the CPA has no skin in the game. He'll turn them over. So I'm hoping those are in the records that auto owners already see from the CPA, but I have no problem looking. As far as inspection reports from the township, I don't have any inspection reports from the township. There was nothing done on our end with the township. If Liberty Township has anything in regards to this property, it'd have to be a FOIA for the township, and obviously they'll turn those records over, but it's nothing I'm aware of.
Where is this property located? I'm curious now, because I live in Liberty Township.
Judge, it's
Gates Road.
If you go down 127 south and you make a right on
Jefferson?
No, it'd be I think it's Liberty Road.
Liberty next after Jefferson.
Right, and then Gates comes in there. You'll see back up on the northeast corner is a older farm. There's a barn there. They do.
So it's on the corner of Gates and
Liberty.
Yeah, it sits back a ways from the corner, but Gates and I think it's Liberty Road.
Oh, I ride my bike out there regularly. I have trouble picturing. Is it obvious there's been some recent construction there?
I can't tell from the road, Judge.
I'm just curious.
I've been to a few matters of it.
I've been out there maybe, I don't know, just personally, maybe a dozen or times more in my whole life. And I was there maybe a couple months ago. I didn't notice anything that was, oh, wow, a brand new building just went up, and nothing like that. There's a house, there's a 2-story garage that's been turned into like a motel rooms. So for guests, they want to rent it out. And then across the street is the actual barn where the events are held. But as far as objections go, when they did the insurance investigation of Mr. Kowaleski, during maybe day 3 of his depositions, they had an expert show up and do a digital sweep of his phone. So they pulled all the information off of it that was relevant for this insurance investigation. So any digital notes he had on there, auto owners already has. As far as physical written notes, I haven't found anything that they're referencing as far as the 12-minute window where he was making some notes. I haven't found that. But if we find any notes that aren't protected by attorney-client privilege or work product, I'll turn them over. But I'm not going to waive ahead of time any of those privileges. And if you look at my Exhibit 8, I asked Shelley for some unredacted documents, and she told me, no, they're protected by attorney-client privilege or work product or made in contemplation of litigation. And if you actually look through the privilege log, there's a bunch of entries before I ever filed the lawsuit. So before June 23rd, 2020. So if it's good enough of a privilege for the defendant, it's good enough of a privilege for my client. That's all I'm saying.
So your assertion of the privilege is simply to make sure that once you do put your hands on these notes, if there is any work product or attorney-client, you've preserved the privilege by making an objection to it.
Correct. And
you really don't know because you haven't been able to find them.
Right.
Whether there really is protectable information.
I told Shelley that I haven't found anything, but I'm just not going to waive the privilege without ever even seeing it, if they even exist. And again, here we are. We're still doing the motion hearing. I don't know why. So is that then the last thing? All the business records. Again, almost all of these things are through the subpoena they sent to the CPA. If I had gotten an extension, sure, I probably could have picked up the phone and got it. But if Shelley doesn't trust my client to turn over the complete records, you know what? Let's cut out the middleman. Let's go right to the source. I would have signed a consent, disclosure to get the paperwork to them from the CPA. But again, Shelley wouldn't take my phone call. She wouldn't give me an extension. So here's where we are. I'm happy to get them the documents. But it sounds like they already have it.
Had you received a response to this?
Yeah, if I can respond. After we filed this motion, plaintiff's counsel did reach out asking for an extension. We agreed to adjourn our motion 1 week to allow 7 more days for them to seek out these remaining documents if they exist. So I think it's disingenuous to say we didn't give an extension. Regarding the phone call, I believe plaintiff's counsel emailed Thursday or Friday requesting a phone call. Ms. Griffin had conflicts, but said Monday at 11, we can have the phone call. So there was no delay in that either. As far as the subpoena, we did subpoena the CPA. We've been in contact with him. He's running behind. So we do not have records yet. He's said he'll try his best to get us to us timely, but as of today, we're left without them. And I think as Your Honor indicated, as plaintiff's counsel said he could contact the CPA, I don't think the fact that we can send a subpoena negates their obligations to provide meaningful, sufficient responses to discovery request. And I don't mean to be disingenuous or unsincere about Mr. Kowaleski's personal matters, but this was started in February. Discovery closes at the end of June, and I'm just fearful that discovery is going to come and go, and we're going to be in the same position we are
Well, let
today.
me put your heart at rest. I'll give you as much discovery as you need.
Okay.
I'm very generous with discovery extensions, particularly during COVID times when it's harder, and particularly when I've got a party that's gone through a significant amount of personal hardship.
And I agree with that. There's deadlines coming, so I didn't want to waive anything.
How much more time, Mr. Bonham, to gather whatever it is you think you're able to gather, taking into account, whatever it is your client's going through?
Sure. I'm just pulling my calendar up right now. Today is the 28th. Yeah, I would say June 18th is realistic.
Let's do that. You can put that in your order.
So the order will read plaintiff is to supplement the
Supplement his
responses by
discovery.
June 18th.
Yeah, I'm not asking him to waive any privilege. I think his position on that is a valid one. If he finds notes that indeed have a issue of work product or privilege, I'm not expecting him to waive that. But if not, and if he finds any notes, obviously he can't produce what he can't find. I think that's reasonable.
I want to, just so we're clear for the order, I'm going to find what we're able to locate. I mean, documents that don't exist or I don't have access to, I can't turn over.
Obviously, I'm not expecting you to. And in terms of the CPA stuff, just coordinate with the CPA. There's no reason of getting it from him twice. That'll just run up the CPA's bill.
Right.
So,
right.
But let's just make sure that your client's cooperating in that effort and encouraging the CPA to turn over whatever he's got.
I can reach out to, his name is Ross Devereaux. I can reach out to Ross and just kind of coax him to make sure that he's staying on top of it. I mean, there's no problem with that. So I think that suffices for everything that auto owners is looking for.
I think so. The one issue that I think it's a subject of motion to quash, though.
Oh, yeah.
Right. Okay.
So just for the motion, want me to start the motion to quash now?
Well, we might as well. The spousal privilege, I think, was already raised in the discovery response. I thought that I heard that mentioned.
Plaintiff's counsel mentioned it. I mean, I disagree with it, so I'm happy to address it.
No. I thought that when you were reciting to me the objections that you had mentioned something about the spousal privilege. So that was my mistake. So let's just move to that, the motion to quash, and whether or not there really is a spousal privilege in a case involving a business entity.
Well, thank you, Your Honor. The statute MCL 600.162, very clear. The spouse shall not be examined as a witness for or against the other spouse without their consent in a civil matter. That includes all communications during the marriage for all testimony, regardless of whether the events occurred before or during the marriage. Both parties must waive that privilege, and divorce proceedings do not by themselves waive the privilege. Mr. Kowaleski, even though he's not a named party to this lawsuit, he cannot have his spouse testify for or against him without both of them waiving the privilege. There is no.
How would it be against him if he's not a party?
If he owns the company, if the argument from auto owners is we want stuff from him because he's the owner of the company, it's either one or the other. They either want the stuff from Don because he's the owner of the company and we want it from him, or he's not a party, so the spousal privilege doesn't exist. So it's just, I can't figure out which way auto owners is going with this one. So if she's going to be called to testify, we have the right to invoke spousal privilege for any communications between Don and Jessica. There's nothing in the statute that requires Don Kowaleski to be a party to a lawsuit for the spousal privilege to apply. There's no case law on that either. If there was, I would assume that auto owners would have put that in their response, but there isn't. And just kind of show you the level of cooperation I may have been getting on this issue. Mr. Girardat's response, which was untimely filed on Tuesday, so I'd ask for that to be stricken, but that's beside the point. He makes an argument that this might be an illegal marriage because we didn't provide a copy of the marriage certificate. I can't even get these defendants to agree he's married. That is the level of cooperation that I'm getting here. So, of course he's married. We're filing for divorce. We provide a copy of the summons. So we're asking that the subpoena be quashed, or in the alternative, that we at least limit the testimony to exclude anything that would be covered between confidential communications between the parties. If there's something that she saw or seen that's outside of that, then I guess if the court wants to allow her to testify, that's fine, but we can at least limit the testimony to exclude things that be covered by spousal privilege.
What I would do here, I'm not going to quash the subpoena. I think she probably has some personal knowledge about the business and the improvements that they're certainly entitled to ask about. I will simply say, if they venture into territory that you believe is covered by the privilege, state the objection, tell her not to answer. I'll address the privilege on a subsequent motion.
I appreciate it. Thank you, Your Honor.
And one more motion?
One more. The motion to the subpoena to Don Kowaleski. It's for 3 different land contracts for 3 other properties and payment histories without any time period attached to them. The first property is for a house in Cement City, but it looks like it's 2 different addresses that's pushed together. So it's 14372 Limerick Lane, Cement City, Michigan, 1009 Woodbridge. So off the bat, not a proper address. I don't know which property they're wanting, one or the other. Hilltop Manor Inn doesn't own either one of these, so I'm not sure how it's relevant to this case. No time frame for any kind of payment histories. Don Kowaleski individually is not the owner of Woodbridge. He sold that property. The land contract for Limerick Lane, that was entered in 2015. It has no logical relation to what's going on to a water pipe bursting 4 years later for a property in a different county. Only intended to harass Mr. Kowaleski.
Well, wait a minute. If he owns other properties that are in financial distress, that could certainly add to his other financial problems and provide an incentive for him to falsify an insurance claim. I think it would be relevant. Now, time period's important. I mean, I think payment history going back multiple years, but let's say the year preceding the incident here, what's owed as of the incident, what is payment history for the year preceding? As long as it shows, is he in arrears? Is he falling behind? I think that's fair inquiry.
That would be fair if they had that as part of the subpoena. So I would ask the court, if you're going to allow the subpoena to stand, that we would at least set a time frame for these, because right now it's in perpetuity. So
why would any more than a year before the loss be? I realize once you get it, it might cause you to ask more, but if the records show that he's current with those payments and was current as of the time of loss, what does it matter if he was behind a year ago or 4 years ago? What would that matter?
I would be fine reissuing a subpoena with a more concrete time period, 1 year prior to the loss,
That's
till
fine.
either he sold
Yeah.
or present. I
Yeah,
would be happy to do that.
Let's do that. And now
And
there's one, apparently you've got a bad address. I think you're going to have to correct that.
And that was a typo, I apologize, but when we reissue the subpoena, we will
Okay.
make that clear.
The other one, I also want to clarify since we're here, the 330 Oakwood, Jackson County. Can we get maybe a little bit more descriptive of an address? I've tried locating it. I think Don used to own one of those properties. But sold it. I believe I attached the BSNA records that shows it's now owned by a new party. So I guess because I don't remember.
I mean, if it was sold under distress because he was way behind in the payment and was just trying to get out of it, and it shows he was behind in the payment, say close to the time of loss. But if it was a couple years ago that he sold it, that sounds like.
Question, Your Honor, is, and I'm making this part up because I don't remember the dates that he sold the property, but let's just say he sold one of these properties in June of 2017. And they want subpoenaed records all the way back, we'll say, to June 2018. Well, that wouldn't cover the time period. I don't want them to think that I'm not complying with their subpoena, but if we wouldn't have those records because the property is already sold. I mean, I would just reflect that in my response to the subpoenas. It was sold before that date.
If it was sold more than a year before the date of loss, you can indicate in response to subpoena that, and I wouldn't require you to produce any of those records.
Okay, I just want to make sure we're all on the same page
Too
right now.
remote.
Well, we're all here. So for the subpoena, for the motion for protective order, I don't know how you want the order to read, but essentially auto owners is going to be issuing a new subpoena for the records.
Consistent with what the court's indicated on the record today.
That's fine.
So Judge, you say 1 year back from today, or are we talking about
No,
1
no,
year
from
prior to
the loss.
Okay.
From the loss.
And Judge, while we're all here, the last time we tried to get a modification of the case scheduling order, Mr. Bonham would only agree to 45 days. And certainly that was back in May, and certainly we're going to need more than that when we don't have anything yet.
We already agreed to an extension in the first part of this motion.
I think that when you agree to cuts out discovery June 23rd, we're gonna go way past that.
I'm just asking how much longer, if we can include that in this order.
Certainly. How far out do you want?
Give them another 90 days. I'm fine with that.
90 days good? And if you
We'll
need
take it,
more,
or we may come back.
if
That's
you
right.
need more, just ask for it.
Will do.
I'm always receptive. I practiced law for 30 years. I can't believe it's been 10 years almost that I've been on the bench, but I vividly remember the practicalities of practicing law. So I'm generally
Extension.
receptive to extensions.
I'm sorry to cut you off. For the extension, is the court gonna issue a new scheduling order, or do you want me to submit an order? with
Submit an
dates?
order with the way we normally ask for it. Rick knows how to do that.
Sure.
Current date, and then, whatever a blank for the new date. So, good. All right. I hope you guys are able to work out these other things without filing discovery motions.
Hey, we're doing really good.
I'm happy to hear them when you file them, but I like to see attorneys working cooperatively, not being uncooperative. And I think you need to be sensitive to things like divorces and deaths.
Hey, we're getting pretty good. Last time it was, I think, 5 or 6 motions. Today was only 3. So we're getting better.
Hey, I like this. Next time it should be only 1 then, right?
I have
Right.
one. Just one.
All right. Thank you, Your Honor.
Thank you, everyone. Have a good day and a good weekend.
You too.
Thanks. Thank you. Hey, doing well. How are you? Great. Good. How's the new practice going? It's going great. All's well. Lost, though. You got trouble with him. I don't know. Yeah.
I don't know, I thought he's gonna ground me, so I can't do that.
Hey, you got the mom card. You have a great union. Thanks, guys. Have a good weekend.
Okay, let me take us off the stream and off the record, since this is just a pretrial. You guys weren't expected to put something on the record, were you?
No, I apologize, Your Honor. Mr. Bielinski called my office this morning, and I was in a